All right, I'm ready to go whenever the panel is ready to go. With the interest of time, are we okay with skipping the formalities of calling the court to order? And I will just let the Chief Justice take it away.
Chief Justice, bring it on. Chief Justice. All right, take it away.
Before I begin, may I reserve 2 minutes for rebuttal?
Of course.
Chief Justice, Associate Justices, and may it please the court. My name is Lenica Valera, and I, alongside my co-counsel, Brett Smith, represent the petitioner, Ms. Andrea Somerville, in the case at bar. I will address the 14th Amendment violation, while my co-counsel will later address the First Amendment violation. Would Your Honor like a brief recitation of the facts?
Of course.
Ms. Andrea Somerville was a distinguished lecturer at Olympus State University. In order to continue teaching part-time, she applied to the law school, and through the Freedom of Information Act, she found that she was rejected due to the discriminatory policy that gave preferential weight to male applicants. She spoke out against this policy and was later terminated for that. The respondent's discriminatory policy that gives preferential weight to male applicants violates the 14th Amendment right to equal protection for the following 2 reasons. First, the respondent cannot meet its burden that this classification passes heightened intermediate scrutiny. And second, the respondent used an unconstitutional de facto quota. On to my first point. United States versus Virginia and secondary case JEB versus Alabama held that all gender-based classifications today are subject to heightened scrutiny. Heightened intermediate scrutiny means that the classification must serve an important governmental objective. The means must be substantially related to the achievement of those goals, and the justification must be exceedingly persuasive. The burden of justification is demanding and rests entirely on the state, as held in Mississippi University for Women versus Hogan, secondary case of U.S. versus Virginia. Previous precedent shows the policy that was implemented is unwarranted. Although diverse...
What previous precedent are you referring to?
I'm referring, Your Honor, to the previous precedent in Fisher versus University of Texas, Regents of California versus Bakke, and Grutter versus Bollinger. Although diversity was upheld as a compelling government interest in those cases, such a policy can be distinguished from the one in the case at bar. In Fisher versus University of Texas, 52% of undergraduate classes had no African American students. Also, in Grutter versus Bollinger, this policy, a race-based policy, was necessary to keep the minuscule 4% of minorities from being overpowered in the classroom.
But isn't there a significant disparity here between male and female students?
Your Honor, petitioner argues that there is not meaningful diversity that would be created by this classification, as was held in Regents of California versus Bakke, because there is not a state interest in raising male enrollment by a mere 10%.
Well, you said there would be meaningful diversity. Define meaningful diversity.
Your Honor, meaningful diversity was defined as a critical mass in the cases that I previously mentioned. The critical mass was entitled by having 4% of minority students, or 10%, but it was nowhere near the 40% split that we are seeing in the case at bar. The respondents...
So if it was 35%, would it be okay then?
Your Honor, in the previous cases, the disparity was much larger than 35%. It was closer to almost 0%.
Well, what I'm asking is, what would be the cutoff for you then?
Your Honor, there isn't a cutoff. There's only the fact that in the case at bar, we are already seeing meaningful diversity. The burden is on the respondent to show that there was not meaningful diversity, and therefore the classification was necessary. However...
I understand what you're saying, but we have to create a law, precedent for future courts to look at, and we need to say, well, at what point does it become meaningful diversity? At what point does the disparity become so large that we have to do this program? So where would the cutoff be for you? At what percent would it be allowable?
Well, Your Honor, that burden is on the respondent. It is not on the petitioner to show where the cutoff is, but rather it is on the respondent to show that without the classification, there is not diversity that satisfies their educational goals. However, we do not see this in the case at bar because they cannot show that diversity was not being upheld. There was no empirical evidence or statistics as there was.
So what are you asking this court to do then?
Your Honor, we are asking for this court to overrule the decision of the lower court and have this classification not be used in OSU anymore.
What would make it constitutional classification would work in this case? You're continuing the one that currently is in place is not working.
Well, Your Honor, the dissent on page 15 listed multiple other ways that the same amount of diversity that the university is trying to achieve could have been achieved. Some of these were using enhanced recruitment techniques, increasing the budget, advertising to male-dominated media markets, or even reaching out to alumni. The respondent has disregarded these neutral alternatives and merely turned towards a classification that is discriminatory. The respondent also asserts that gender was one of many factors. However, page 7 of the record shows that every female that was accepted met or exceeded Ms. Somerville's portfolio. Therefore, gender became more than a plus factor, but rather was a barrier to her entry. Therefore,
Is this the only law school that she applied to though?
yes, Your Honor, this was the only law school that she applied to. However, in the case of Grutter versus Bollinger and Fisher versus University of Texas, non-minority applicants were frequently accepted with lower scores than those of minority applicants. In the case at bar, we do not see this, as no female was accepted with a lower score than a 159 or a 3.5 GPA, whereas many males were accepted with scores as low as 150 and a 3.0 GPA.
Why really only a GPA and LSAT metrics? Those male students brought many things that Ms. Somerville did not bring to law school. Shouldn't we allow the law school to look at those additional metrics?
While it could be permissible to have soft factors in a holistic review, it was not necessary in the case at bar, and it was an intrusive means in order to achieve a goal that was not necessary and therefore it is not substantially related to the achievement of that goal.
How is it intrusive?
Well, Your Honor, it is a discriminatory policy and therefore it is intrusive, and it was not regarding a gender-neutral alternative that the respondent could have used in order to gain a larger enrollment of males in the law school.
Go ahead. Could you take me back? Are you saying that the law school did not have an interest in diversity, or that diversity is an interest but it's not? I think you're walking in a circle around the idea of diversity here. Could you clarify where the law school stands on being allowed to take diversity into account?
Well, Your Honor, I do believe that diversity has been upheld as a compelling government interest. However, petitioner does argue that the use of diversity in the case at bar is not necessary, considering there was already meaningful diversity in the law school. Along with this, the recitation of a compensatory...
Didn't you tell us a moment ago that the law school doesn't have the statistics to say that diversity was meaningful? This is where that circular problem is existing. You're saying it wasn't useful, they're saying that it is, and then you say they don't have statistics to back that up.
Yes, Your Honor, they do not have statistics showing that there's not already meaningful diversity at the law school. Along with this, the recitation of a compensatory purpose does not protect against any inquiry into the underlying purpose of the statutory scheme. Petitioner argues that the use of diversity was not the true meaning behind this classification, but rather it was being used in order to maintain the Tier 1 ranking as they expressed on page 5 of the record, showing their chief interest was in maintaining their Tier 1 law school, not in having a diverse student body.
Well, you said that soft factors are allowed. Is that correct? Is that your position?
Yes, Your Honor, under Grutter versus Ballard.
Okay, so what soft factors did your client bring that in addition to her LSAT and GPA?
Your Honor, the record does not show. However, she was a distinguished lecturer at Olympus State University in Women's and Gender Studies. So I see I'm running out of time. May I finish my question?
Chief Justice, may she finish her question?
Of course.
Thank you. Could you repeat it? I'm sorry.
Oh, my question was what soft factors did she bring?
Okay, Your Honor. Your Honor, although the record does not show that she brought other soft factors, it also does state that she was a distinguished lecturer at Olympus State University in Women's and Gender Studies, which shows that she did have other classification that brings her above other applicants, along with the fact that she had a high GPA and LSAT score that many of the males did not bring. And for these reasons, we ask that you reverse the decision of the lower court.
Thank you very much. All set.
Chief Justice, Associate Justices, and may it please the Court. My name is Brett Smith, and I, alongside my co-counsel, Linica Valera, will be representing the petitioner in the case at bar. I addressed the First Amendment issue, while my co-counsel has already addressed the 14th Amendment issue. The question to the Court today is whether the respondent violated my client's right to freedom of expression under the First Amendment of the Constitution. And we say yes, for two key reasons. First, due to the inclusion of academic freedom, Pickering versus Board of Education is the proper metric to establish protection under Ms. Somerville. The second is that, as outlined in Orozzi versus Gilmore, whenever you infringe on a cornerstone of society such as academic freedom, then a dangerous precedent is set for the future. On to my first point, the Pickering analysis. Pickering, as then expounded in Adams versus Wilmington, established a metric that one has to meet in order to be protected speech. Those three metrics are as follows. The first, that she was speaking as a private citizen about a matter of public concern, or instead of an employee on a matter of private concern. The second is that her interests as a speaker have to outweigh the interests of the state, being an efficient and effective university. And then the third is that her speech has substantive use in whether she was fired or not. If we follow the metric and look at the facts of the case, Ms. Somerville met all of those metrics, starting with the first.
Pickering came before Garcetti versus Bios, correct?
Yes.
So why shouldn't our holding in Garcetti about speech in employment context be the controlling test here?
Well, two key reasons, Your Honor, two key cases. Those are Dimmers versus Austin and Adams versus Wilmington, both of which are very important to the case at bar. Let's look at Dimmers versus Austin first. In that, it established that in speech related to scholarship or teaching, then Garcetti would not apply. On top of Adams versus Wilmington, where it said that in speech in the context of a public university, Garcetti wouldn't apply, and then stack that with the idea that Garcetti specifically included an exclusion for academic freedom in the first place. It shows that Garcetti is just not the applicable reason in this case. It's not the applicable
cases
case.
that say the opposite? I mean, why is the interpretation of Garcetti in conjunction with those cases that you just cited the right rule that this court should adopt?
Well, there's two reasons for that, because it's a bit of a two-pronged question. The first of which, if there are cases that go specifically against Garcetti, this is a closed case, so I can't specifically use them. And so because of that, I have to take the cases that I have. The second is that whenever looking at the cases that we do have, the cases that I've been presented, those are the most analogous to the case at bar. And so because of those, we have to look at the legal context and the legal reasoning behind what they did, and then apply it to the case at bar for every similarity that they may share.
But why is that a good rule? I guess that's a simpler question. So why is creating an academic exception to Garcetti a good policy that this court?
The reason would be the case is because when dealing with teachers or professors, it's a very murky ground on whether something is in furtherance of their core duties. Because whenever you're a teacher, pretty much everything can be considered in furtherance of your core duties if you're establishing it in any level of teaching manner.
So going on Ellen DeGeneres is teaching?
If it were to apply the idea of gender and women's studies, and then given to an audience, then the line of communication is the same. There was a sender and a receiver, and she was speaking about exactly what was in furtherance of her core duties, but Garcetti is the exclusion of academic freedom. And so the petitioner can concede that she was speaking about something that was being a teacher, but that's very murky ground on what's in furtherance and what's not, which is why Garcetti gave the exclusion in the first place. And then
It takes a lot of power away from the university as an employer, doesn't it? And if you can really push any speech under this academic freedom, how can a university really discipline its employees?
Your Honor, that actually brings me to my second point of Orofsky versus Gilmore. Although speech, when protected, doesn't necessarily insulate one from disciplinary action, we have to look at the facts of the case and then look at the establishment of who she was as a university professor, and then go on to the third metric of Pickering, which is that what she said was a substantive reason for her firing in the first place. And so, insulating something from disciplinary action doesn't necessarily mean that she can say whatever she'd like, but in this case, she had not said anything thus far, never had been reprimanded. There's no records of complaints. There's nothing to issue the idea that Ms. Somerville was not a stellar lecturer at OSU, which leads the court to believe and leads the petitioner to believe that the only reason she was fired was because of her speech at Unity Fest. And if that were to be
But isn't
established,
that why she can be fired? Because they weren't dealing with her speech in the classroom. They were dealing with her speech at Unity Fest.
both of those things will apply. Because when speaking as a speaker at Unity Fest, she was speaking at that time as a private citizen. And so then the Pickering analysis doesn't even have to be applied, and the Garcetti doesn't even have to be applied, because we're no longer speaking about her ideas and her methodologies and her communication in the classroom. We're talking about her speaking at a public festival, in which case it's a very simple metric. She was speaking at a public festival and they fired her for it, and the only reason they
Wasn't
fired
she speaking at that public festival as a representative of the university?
No, Your Honor, she wasn't. She was speaking as a lecturer in the Department of Gender and Women's Studies. But when it comes to free speech, it's very important to be specific in what Ms. Somerville said. And what Ms. Somerville said was that she was a lecturer, but OSU specifically was not mentioned in her speech. Other than the poem.
Statements hostile towards men.
I'm sorry, Your
Didn't
Honor.
you make statements hostile towards men as a class?
Are you speaking about Unity Fest, or are you speaking about her?
Any of her statements?
So in the record, it doesn't specifically state that she said anything hostile about men as a gender, but it does state that she was speaking to specifically male students whenever addressing them in the classroom, which leads me into my second point, Orofsky versus Gilmore and that dangerous precedent. Because if we look at Orofsky versus Gilmore, it sets up this idea of academic freedom as a cornerstone of society as it stands. And they also go on to say that academic freedom, whenever it's infringed upon, then a lot of other cornerstones of society would fall.
Define
And so,
academic freedom as you would have us define it.
okay, academic freedom is the conviction and the protection from termination, imprisonment, or reprimandation based on the ideas as well as the nature of the speech itself. And so
does that protect harassing speech that would otherwise be a violation of Title VII?
no, Your Honor.
Why not, according to your definition?
Okay, because there's a distinct difference between being critical of a student's ideas and being critical of a student themselves. And in this circumstance, that's what we have to look at. Ms. Somerville was not showing that she was reducing herself or having some downtrend in her ability as a professor. In fact, the petitioner argues that it was an uptrend because she was engaging students in debate that they would have to utilize throughout the rest of their life. She was being the picture-perfect professor when she did so. And she
Where
was
do we draw the line with the school's power to control their employees, such as the Associate Justice said earlier? It seemed that she was causing the school to lose its source of revenue when the donors were pulling out because of her criticism of the law school. So where do we draw the line? When is the school able to actually control its employees to where they don't cause a detriment to the university itself?
Well, a more valuable line to look at, if I can go back to Orofsky versus Gilmore, is the precedent that this court will have to set. And the reason that I bring that up, and the reason that I brought academic freedom up, is because you spoke about the donations, and I'd like to go back to that. If the donations that someone gives to a university can determine who is teaching at the university, then what kind of precedent does that set for the future? Will professors no longer be judged on their merits and no longer be employed on their merits, but instead will they be employed on how well they can keep their mouth shut? How well they can stop talking about the university? And that's the important line in the case at bar. What precedent will this court set for the future on whether donations can determine who is employed at a university in the first place? If Ms. Somerville can say something that the majority of the donors don't like, then does that mean that she's immediately terminated because of it? And then what does that lead into? When does that line stop? And it's for these two key reasons that we ask that you err on the side of the petitioner in the case at bar. That academic freedom, that dangerous precedent that y'all What's that? Thank you.
Yes.
Chief Justice, Associate Justices, and may it please the Court. My name is Kobe Menard, and I, along with my co-counsel, Olivia Kidry, represent the respondent, Olympus State University, in the case at bar. I rise to address the Court on the 14th Amendment issue in this case, and my co-counsel will later address the First Amendment issue. Turning to the equal protection issue in this case, the question before the Court is whether the policy enacted by Olympus State violates the Equal Protection Clause, and we respond to this question with a resounding no for two important reasons. The first is that Olympus State has an important interest in the diversity of its classrooms, and the second is that the policy is substantially related to furtherance of those diversity interests. Ensuring a diverse educational environment and obtaining the educational benefits which flow from diversity leads to students who are better prepared to succeed in the heterogeneous society that awaits them upon graduation. As the leading law school in the state of Olympus, Olympus State graduates regularly go on to obtain employment in the public sector and government agencies in and around Olympus. It follows.
So let me ask you the opposite question I asked your opposing counsel. They're arguing that 60-40 disparity is still diverse. You're arguing that it's not sufficiently diverse. So at what point would it become sufficiently diverse? What if it was 55-45? Would that justify your policy?
Well, Your Honor, I think that the important focus of the Court should be on the fact that the Court has never quantified at what exact level of diversity is in a classroom, and for two important reasons. I don't think anybody can argue that diversity has a limit. And when we speak about diversity, we are speaking about the specific educational benefits which we get from diverse classrooms.
I mean, I understand that, but we have to set a precedent, just as I pointed out to your opposing counsel. Going forward, courts are going to look to us for guidance, and we can't just say, I mean, if we say 60-40 is, either way, if we say it is diverse or isn't diverse, that still doesn't tell us, the other courts, okay, what about 59-41 or 61-39? We need to give some more clear guidance than just saying, on a case-by-case basis, every time we have to look at specific percentages. So tell us where you would draw the cutoff. What is diverse?
Your Honor, sure. I think in the context of gender classification, I think our focus on a best equitable split is the best possible form of diversity that we can achieve because of the interests we're seeking. We are seeking to improve the cross-gender understanding in our classrooms, to improve those robust conversations, and we feel that in a society which is day by day growing more heterogeneous, we're seeing more equity between the genders in the workplace and government agencies.
So on this point, your opposing counsel suggested that you did not put forward sufficient statistics or information to justify this. Do you have a response to that?
Yes, Your Honor. I think two important points. One, in the second iteration of University of Texas v. Fisher, the court said that it was a heavy burden that we faced, but two important contexts for that. One, the court was looking at a racial classification system in that case under strict scrutiny. Here we have a gender classification under intermediate scrutiny. So I think that does lessen the burden slightly, but pardon me, Your Honor. So I think that does go to
A less than needed statistics.
absolutely, Your Honor. But secondly, I think that it is important that we be able to maximize the benefits that we're seeking, again, those educational benefits. And so I think that, again, we would love in the future, I mean, it's outside of this record, we would love to be able to show the court one day that we have maximized the educational
But Counselor,
benefits.
isn't there more gender neutral means of achieving your governmental interests? For example, more heavy focus on the soft factors, because even if you were to primarily focus on the soft factors, Ms. Somerville wouldn't have gotten it in the first place, despite the fact that she is a female. So what do you have to say about that?
And Your Honor, we have attempted gender neutral alternatives in the past. We've increased our recruiting budget by 20%. We've gone out to other undergraduate institutions in the state of Olympus. Again, our focus is, again, not on our numbers, Your Honor, that's not the ends of our goals. Those are just the means that we seek. Because we are seeking these educational benefits, having a lesser disparity between males and females in our classrooms is simply the means to achieve those. So we have...
Well, that's an end, not a means. Right? So the question is, how do you achieve more diversity? Why couldn't you be given just scholarships? male-only scholarships?
Well, Your Honor, we have reached out to prospective male students in the form of incentives for applications. We have gone and used a few of those gender-neutral alternatives, and the court said
Well,
it.
you didn't use male-only scholarships, did you?
Well, Your Honor, I mean, I don't know an answer, Your Honor, but even if we did, Your Honor, in Bollinger and in both iterations of Fisher, the University of Michigan and the University of Texas had used targeted scholarships toward minority applicants and still was able to turn towards a racial classification system. So we believe that even if we had used scholarships targeted towards male applicants, it still would, we still had not achieved those goals that we seek, we still would be able to turn to this policy. And if I can turn to my second point, Olympus State's use of gender in its admission policy is substantially related to its goal of attaining the educational benefits which flow from diversity. As noted in the record, OSU uses an individualized, holistic process which evaluates prospective students on a range of variables, which could contribute to both the diversity in the classroom and the overall diversity of the university. And this ensures that gender plays no greater role than is absolutely necessary in implementation of this policy and furtherance of Olympus State's diversity
That goes
interests.
back to my first question, Counselor. What's the point of the gender classification if soft factors do the job?
Again, because we're seeking to maximize those educational benefits, and because historically the imbalance between male and female students in our classroom has been high and higher than the majority of the top 25 and top 50, even tier 1 law schools, we feel that we haven't reached the maximization of our benefits yet.
Can you differentiate between whether gender played a larger role in the soft factors of some applicant getting into the university? Can you make that differentiation there?
Well, Your Honor, I think in the record it does say that had she been a male, to Your Honor's question, had she been a male, she would have been admitted. But we can see that there, I'm sorry, could you repeat your question?
Is there a difference? Can you distinguish whether being a male was the dispositive factor of an applicant getting in over the soft factors?
No, Your Honor, I think because our policy does not, gender is but one factor that we use to evaluate a prospective student.
So then you can see that there's no point for the gender classification, correct?
No, Your Honor, I don't think there's not no point. I think gender, the court has instructed us to use gender or to use a discriminatory classification as a factor of a factor. We can't have it be the be-all, end-all in decisions that we make with our prospective students in their application.
So you're arguing that diversity is your goal, correct?
Yes, Your Honor.
Well, if you look historically, the legal profession was pretty much 100% male just a few short decades ago. So wouldn't this argument for diversity actually mean you should allow a temporary inequity largely in favor of women students so that the overall legal profession balances out?
Well, Your Honor, no, Your Honor, because the court has turned its focus in the interest of diversity to, again, achieving those educational benefits and not an attempt to correct past disparities by a minority group. We believe that that is the court's primary focus because the court understands, as we do, that discriminatory classifications, especially in the context of college admissions, do run up against the equal protection guarantee that's found in the Constitution. So the court wants a university's focus, and when they make an academic judgment to improve their diversity interest by using a discriminatory classification, to be on achieving those benefits and not on correcting past wrongs or simply conducting a balancing test. Now, OSU does believe that a more equitable ratio of male and female students in their classrooms, which again is mirroring or starting to mirror the balance that we're seeing in our society at large, allows for the maximization of our diversity interests. Despite what
What specifically is your law school lacking if you have, let's say, as you, 60% women in the class and 40% men? What are you lacking exactly?
Well, Your Honor, I wouldn't necessarily argue that it's a matter of lacking, but our focus is to maximize those benefits. We believe that improving that cross-gender understanding, making sure that the conversations that occur between men and women in our classroom are the most robust form that they can be. We don't feel that we have a lack, but we do feel that we have not reached our maximization. And that would be our argument. Despite what the petitioner has argued, this does not constitute a quota system. We do not set aside seats, and we do not have male students apply on separate tracks than their female respective colleagues. For these two reasons and those that I've outlined above, we ask the court to affirm the decision of the 14th Circuit below. Thank you.
Floor is yours.
Chief Justice, Associate Justices, and may it please the Court. My name is Olivia Guidry, and I, along with my co-counsel, Kobe Menard, represent the respondent, Olympus State University, in the case at bar. As my co-counsel has addressed the 14th Amendment issue, I address the First Amendment issue. The question before the Court today is whether the respondent violated the petitioner, Andrea Somerville's, right to freedom of expression under the First Amendment to the United States Constitution. We answer with a resounding no for the following crucial reasons. Somerville was speaking as a public employee pursuant to her job duties, and the respondent was justified in firing her in order to maintain the function of the university. To cite Garcetti v. Ceballos, a public employee's statement is protected by the First Amendment when 1, in making it, the employee spoke as a citizen, 2, the statement involved a matter of public concern, and 3, the government employer did not have an adequate justification for treating the employee differently from a member of the general public as a result of the statement he or she made. We argue
In
that
a response to the petitioner's submission, we should instead be looking at the concept of academic freedom versus Garcetti. That Garcetti carved out an exception for academic freedom. We really should be looking at that and not the basic Garcetti test.
no, we argue that we should be, Your Honor, we should be looking at the main Garcetti test because we argue that Somerville did not uphold the first two stipulations of the Garcetti and that OSU indeed had an adequate justification for terminating her employment. So looking at the first point, Somerville was not speaking as a private citizen, but rather pursuant to her job duties. First, looking at Unity Fest, which we argue is not the sole reason for her termination, but definitely a factor in that.
What was the reason for her termination?
We believe it was a culmination of factors, Your Honor, including her performance in the classroom as well as what she said at Unity Fest. So looking at the circumstances surrounding Unity Fest, though Somerville was not primarily introduced as an OSU faculty member, and though the case of Urofsky versus Gilmore states that in regards to
Didn't your own administration offer her up as a potential speaker for Unity Fest? It could have, you set her up to fail if that's the case.
yes, Your Honor, but it was the people who she interacted with on a day-to-day basis and not the dean and everyone in charge of OSU. They were unaware of the speech she was going to give.
Did those employees get terminated because they apparently did not have the authority to grant her access to this venue?
No, Your Honor. Though Urofsky versus Gilmore states that the location of an employee's speech is irrelevant in regards to their First Amendment rights, Somerville voluntarily introduced herself as Miss Andrea Somerville, a lecturer in the Department of Women's, Gender, and Sexuality Studies, thus in a way waiving her right to speak as a private citizen, because this makes the university concerned with what she is saying, particularly if what she
is
is.
supposed to hold up a sign with an asterisk, not speaking in my official capacity. I mean, what's she supposed to do? We have to give a test that courts can apply in the future. So how can we shape future cases with your position?
Well, Your Honor, while she's not restricted from speaking about things she teaches in the classroom, which in this case would be affirmative action, she should be aware that because affirmative action is a university-approved topic that she is to teach, she should be aware of what, when she is speaking about it, that is a reflection of the university.
So
And
every
that
time she talks about gender-related issues, it has to comport with university standards of what they should be saying on those issues?
Well, Your Honor, if we look at Sweezy versus New Hampshire, we see that the 4 essential freedoms of a university are to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. So because the third stipulation states how it shall be taught, if Ms. Somerville is speaking in public or in
But
a
it's not in the
venue,
classroom. So she's not teaching in the classroom in that instance then.
no, Your Honor, but it is a subject that was approved by the university for her to teach.
But that would
She's
mean
therefore-
so that means any time a teacher, an instructor at a university speaks in any capacity on their expertise outside of the classroom, they're still considered speaking on behalf of the university.
Yes, Your Honor, because if we look at Urofsky versus Gilmore, it states that a public employee can speak in their official capacity off of the grounds in which they work.
I understand that, but under your definition, it would always be the case, and there's nothing a public employee could do to say, I'm not speaking on behalf of the university. A teacher would say, well, because this is my area of expertise, I must by definition be speaking on behalf of the university. If I understand your argument correctly.
Yes, Your Honor, but we argue that because she introduced herself as a professor, then she is sort of saying that she's speaking in her official capacity.
Did she introduce herself as a professor when she went on the Ellen show?
No, Your Honor.
So was she chastised for speaking her opinion on the Ellen show?
No, Your Honor. We believe that the things that led to her termination were her speaking in the classroom and unit investment of our radio that resulted from it.
So in order to delineate a test, when does a university employee shed the cloak of being a public employee? When can they go and engage in public discourse in the political process without any type of repercussions from the university employee?
But what would they have to say or do to distance themselves enough from the university to say, this is just my private speech, I have no connection to any public employee? What would they have to do to make them insulate themselves from that kind of repercussion?
Well, Your Honor, we're not saying that Ms. Somerville can never speak about gender-related issues, but when she speaks about specific topics such as affirmative action or why women are disadvantaged or her specific case, then we are saying that she's speaking in her official capacity.
Right, because isn't affirmative action and the university's affirmative action policies a matter of public concern? Shouldn't she be encouraged to engage in public discourse?
Well, Your Honor, that brings me to my second point. Somerville was not speaking on a matter of public concern, but rather as a matter of personal interest, which namely was an indignant outcry against OSU Law School for rejecting her application. As we see in Urofsky versus Gilmore, speech involves a matter of public concern when it involves an issue of social, political, or other interest to a community. An inquiry into whether a matter is of public concern does not involve a determination of how interesting or important the subject of an employee's speech is.
But isn't gender equality and affirmative action, aren't those issues of public concern, not private concern?
Yes, Your Honor. But we argue that the only reason this is seen, that Somerville's speech is seen as a public concern is because of the popularity her viral video gained, which popularity does not equate to importance. So just because the video of Somerville reciting her poem was a source of viral entertainment doesn't mean that her speech was on a matter of public concern. Unity Fest and all the other venues she spoke in.
Why do you think it got so popular then? Because clearly the public became concerned about the video. It generated a lot of public interest, so why would you be so interested?
Yes, Your Honor, but public interest does not equate public concern necessarily. Just because people may find a video entertaining or fun or interesting doesn't necessarily mean it's on a matter of public concern.
So what are matters of public concern? You're saying this is not what would be. If you have a case that has an example of what.
No, Your Honor, I do not.
Would affirmative action generally be a matter of public concern?
Yes, Your Honor, typically it would be.
So is your position that when she started to speak about her personal experience, it moved away from being a matter of public concern?
Yes, Your Honor.
Okay.
Finally, looking at my third point, the respondent had an adequate justification for terminating Somerville's employment. First, if we take a page from Connick versus Myers, we see that the fact that Somerville's vocal complaints against the university in all venues emerged directly after the law school rejected her application requires that additional weight be given to the respondent's view that Somerville threatened OSU's authority to run the university. Somerville explicitly mentions OSU in her poem, thus giving a more specific name to the they that she was attacking, referring to them as, quote, the sons of bitches.
Does the university have to have actually been damaged for that argument to work? Or is this just a threat to the university's status enough?
Well, Your Honor, if we once again look at Connick versus Myers, we adhere to the fact that the university is not required to tolerate action that it reasonably believed would disrupt its function, and we see that because Somerville's speech received backlash and the university was contacted by parents of students, groups advocating for men's rights, alumni and donors, many of whom said that they would withdraw funding from the university if Somerville's employment were not terminated. The university has adequate reason to believe that Somerville's speech would be affecting its function. The case even states that the loss of funding would directly affect the function of OSU's athletic programs. Not to mention that the onslaught of calls in the office would definitely back up the function of the university because people have to be answering these calls. In conclusion, because Somerville is speaking as a faculty member pursuant to her job duties, and because the respondent violated no applicable statute when terminating her employment, we respectfully request that this court would find in favor of the respondent and uphold the ruling of the lower court.
You may proceed.
May it please the court. I would first like to address points made by the 14th Amendment. First, the respondent has the ultimate burden to show that neutral alternatives do not suffice, and they have not satisfied this burden, especially on page 15 of the dissent, which listed multiple other ways that diversity could have been achieved.
Is it a dissent of the law?
No, Your Honor, it is not the law, but considering that neutral alternatives it has to be shown that neutral alternatives do not suffice. And if the dissent listed multiple ways, then there were clearly other ways that
They have to
may-
use every possible neutral alternative.
while they do not have to use every neutral alternative, they do have to show that neutral alternatives do not suffice, and they have not satisfied this burden.
Well, they did try some neutral alternatives, did they not?
Yes, Your Honor, they did.
Well, why wasn't that enough?
Because to show the burden that neutral alternatives do not suffice, it takes using more than a few tries before implementing a discriminatory policy.
So what time does it take?
Your Honor, there is not a set precedent as to how many times it takes, but empirical evidence does have to be shown, and there is no empirical evidence as well showing the classification is necessary, and asserting an interest in the educational benefits of diversity writ large is insufficient. On to the First Amendment point.
Well, wait, you said there has to be empirical evidence. Did Greater College offer empirical evidence as to the benefits of diversity?
Your Honor, they did not offer empirical evidence in that sense. However, Fisher versus University of Texas produced a 39-page essay showing that minority students were often subject to stereotypes, and a survey was also produced in Grutter versus Bollinger, whereas in the case at bar, there is no evidence that there was not a cross-gender understanding or that students were subject to stereotypes. And it is for these reasons we ask that the decision of the lower courts be reversed.
All right, we will give the panel time to fill out their score sheets, and then we will come back for feedback, and while y'all give the feedback, I'll total up the scores. So we'll let the panel work on their sheets. And everybody that's here, we need a team picture. We gotta go collect outside.